Yes, hello everyone. Yes, welcome back to my channel. My name is Arinitu Arthur, aka the Light Lawyer, and I'm here today with an interesting topic to discuss, and that topic is the lawmaking process. How are laws made? So that's the topic that we are going to be discussing today. So before I can start, what is law? Well, first, by defining what law is and what are the processes, what are the provisions of the lawmaking process, and we try to scrutinize and go depth on the lawmaking process. Now, if I may start, the definition of law, this refers to a set of rules governing a particular locality, or you can say that a law, it refers to a set of rules opposed or imposed by the sovereign towards the inferior. For example, the government can impose laws, and now those laws are supposed to be binding and must be respected by the inferior people who are non-superior. So, and failure to implement these laws, there is always a sanction, or what we call a punishment. For example, if you look at the Penal Code Act, you see that there are various crimes, and if at all you commit any offense in the Penal Code Act, there is always a punishment given. So, let me go straight away to the lawmaking process. The lawmaking process, we have Article 79. Article 79 of the 1995 Constitution, it empowers the Parliament to make laws for the state as to promote peace, order, and development. So the Parliament has a duty, has the mandate of making laws. And according to Article 91 of the 1995 Constitution, the Parliament, it makes laws called the bills, and such are assented to by the President after 30 days. So, meaning that the Parliament makes these laws in form of bills, and after they are taken to the President, and the President has to assent them in order for them to become laws. Another provision that we're having Article 94 of the 1995 Constitution, and this one empowers the Parliament to enact laws to guide the procedure for making laws. And due to this provision, the Parliament enacted the parliamentary standing orders to guide and give procedure while making law. So, according to Article 94, it provides for the laws that give procedures. And by following Article 94 of the 1995 Constitution, the Parliament enacted what we call the parliamentary standing orders. And now these parliamentary standing orders, they are rules that help and guide in the making of these laws. And if at all the Parliament does not adhere to the parliamentary standing orders and does not adhere to the Constitution, those laws that are being made are null and void. Therefore, when the Parliament is making these laws, they must adhere to the Constitution, since the Constitution is the grand norm, and also they must adhere to the parliamentary standing orders. And failure to do that, then those laws are null and void. Then, if we can proceed, there is a landmark case. It's a case of Maria Matembe and others versus the Attorney General. It's Volume 3, High Court Bullet 2003, on page 84. Here, the Constitutional Court held that the legislature is the one to make law, and it should not be interfered by the courts or anybody, since it drives the authority in Article 79, as I earlier mentioned. And also, there is this landmark case that talks about the supremacy of the Constitution, that if at all a law is being made by the Parliament and it's inconsistent with the Constitution and it's inconsistent with also the parliamentary standing orders, it's null and void. We have this case of Paul Kagwaso Mogerere and another versus the Attorney General, number 3 of 2000. Here the court held that the Constitution is the supreme law of the land and has binding authority on all persons, and any other law inconsistent with it is null and void. So this clearly explains that any law that is enacted by the parliament must be in line with the constitution, since the constitution is the supreme law and it's the grand norm according to Article 2 of the 1995 Constitution. So if we can move further on Article 75. Article 75 of the 1995 Constitution, it provides that the Parliament is prohibited from enacting a law that establishes a one-party state. And also, according to Article 92 of the 1995 Constitution, it prohibits the Parliament from passing laws that alters the decision or the judgment of the court. So meaning that any law that is retrospective, that acts retrospectively, it's null and void. So meaning that the powers of the parliament to make laws, it's limited. It's limited in a way that it does not pass any law that acts retrospectively. Then now, since we've said according to Article 91 that the parliament makes laws called bills, and these bills are the ones that are settled by the president to become laws. Now the question is, what is a bill? Now a bill, this refers to a draft piece of legislation presented to the House of Parliament for discussion before making it a law. Now a bill, it's like any person can pass a motion and they bring a bill in the House. Now this bill is like a draft piece of legislation presented to the House of Parliament so that they can discuss on it, and after discussing and scrutinizing it, it's taken to the president to be asserted to. And after it being asserted to, then it becomes a law. We have processes how this is done. And this one is guided by rule number 115 of the Parliamentary Standing Order, which prescribes the form, publication, and introduction of the bill to Parliament as stipulated in Article 94 of the Constitution. And through this provision, this derives us to now the various forms of bills, or the types of bills that we have. We have number one, we have the government member bill, and also we have the private member bill. Now, a government member bill, this refers to the bill that is brought by a minister, whereas the private member bill, this is the bill that is brought by any member of parliament. So the government member bill is the one that the minister is the one that brings this bill, whereas a private member bill is the one that is brought by any member of parliament. Then we also have another procedure that must be adhered to. And this is provided for under rule number 118 of the Parliamentary Standing Orders, and it provides that the Parliament requires a certificate of financial implication signed by the Minister of Finance before the bill is being discussed. So if at all, let me say, any minister or a member of Parliament brings a bill, he or she must be accompanied by a certificate of financial implication. So after all this being adhered to, now the bill undergoes various stages. And now these stages, we are going to first deal with the first reading. So the first reading here, let me say, if at all it's a minister brings out the bill, introduces the bill and the copies for easy reference for the bill, and they are distributed to every member. And this is provided for under rule number 128. And under the first reading, they only read the short title and the long title of the bill. And then after, the bill is then considered to be read for the first time. After that, the bill is sent to the appropriate committee within the parliament for further scrutinization. And the parliament gives that committee 45 days to scrutinize that bill, and after those 45 days, it has to report back to the Parliament with its findings and reports. But however, if at all the Parliament, if at all that respective committee cannot scrutinize the bill with only 45 days, it can request for an additional time, and if at all that additional time is granted, then it has to comprehend and finalize everything within that additional time, and after that it has to bring back the report and its findings to the Parliament. Then after, we go to the second reading. The second reading here, the member of the bill or a minister can move the motion for the second reading. After moving a motion for the second reading, now here the committee brings out its findings, and the people, they discuss on its findings, and they look at various provisions within this bill, and then after that, then the bill shall be examined in detail, considering one clause, sub-clause at a time. So here, basically, with the second reading, is that the House shall scrutinize and debate on the bill. After scrutinizing and debating on the bill, they shall add and deduct anything they want, and after that, here, then the Speaker shall leave the chair and assume the chairmanship of the committee of the whole House. So here, in this case, in the second reading, is whereby the Parliament, the Speaker shall sit as the Speaker, as the chairman of the House, and after sitting as the chairman of the House, and they shall finalize with the second reading. And after that, then they go to the third reading. So on the third reading, the House shall proceed to the third reading under the motion that the bill shall be read for the third time and do pass. So basically on the third reading, yes, so basically on the third reading, after the House has sat, then they shall read for the third time. After reading for the third time, then the clerk shall prepare copies to send to the President for assent. Now another stage is assent. So assent, according to Article 91 of the Constitution, it provides that the President shall, within 30 days after the bill is presented to him or her, assent to the bill or return the bill to Parliament with the request that a bill or a particular provision of it be reconsidered by the Parliament, or notify the Speaker in writing about the decision. So meaning that after the bill is sent to the President for assent, here the President can either accept assent to the bill to become a law, or can refuse to assent and give his reasons in writing. So the bill may be reconsidered and then presented for presidential approval for another time. So if at all the President fails to approve for the first time, takes it back with reasons to the Parliament, then the Parliament shall again sit and take it back. And if at all the President again brings it back for the second time, then the Parliament has the power to pass it as law if the President returns it to Parliament 2 times. And this has to be on a condition that there has to be a vote for 2/3 of the members of Parliament. So if at all the members of the Parliament 2/3 they pass it as a law, then it shall pass. So after, let me say, the President has assented it as law, then it shall be published under the Gazette, Uganda Gazette. And also, I forgot to tell you that if at all the bill is taken to a committee for scrutinization under the first reading, if at all it's taken to the respective committee for scrutinization, it shall be published in the Uganda Gazette calling civil people from the civil people to come and debate other experts, and so that the parliament can be engaged in the making of the bill. So basically that's it about the lawmaking process, how the bill can become into law, the stages it undertakes, the process, the time frame, the duration, the rules, the parliamentary standing orders that they must adhere so that this bill can become into law. So, ladies and gentlemen, if at all you find this video, this discussion helpful, please subscribe. And also, if you have any other question, you can feel free and ask the question in the comment section. I will reply. And also, you can share it to your members, to your class group, so that they can find this discussion helpful. And so, if at all you like, subscribe so that you do not miss out. So thank you very much. Sign out.